Clause is important. I think. Terry.
Are you all ready?
We are ready when you are.
Okay, so we're gonna reconvene our evening session for the Planning Commission, the City of Monterey.
Just 1 second. I just need to confirm. Are you able to record? I'm sorry. I jumped
Recording
ahead
in
a little bit.
progress.
Thank you.
There you go.
You.
Yeah, roll call.
Yes, we have Chair Fletcher,
Here,
Vice Chair Milich,
On Zoom.
Commissioner Brassfield,
Present.
Commissioner Dawson,
Here.
Commissioner Freeman here, and Commissioner Latassa.
here.
Great. We are all present at this time. And for city staff, we have Community Development Director Kim Cole, City Attorney Christine Davi, and my Recording Secretary Jennifer Cleary.
Okay, thank you. We're gonna take some public comments, but first, could you explain how people can participate online?
Definitely. Members of the public are encouraged to join our meeting via Zoom Gov, a secure service that connects you live at time. This meeting is also streamed live on youtube.com/City of Monterey with a 10-second delay and Comcast channel 25 with up to a 90-second delay. If you would like to provide public comment, please join the meeting using Zoom or by telephone, making sure to join in time to accommodate delays. To join the Zoom meeting from a computer or phone, use the link or phone numbers on the agenda posted at isearchmonterey.org. Since the meeting has begun, you'll find the agenda under the Recent tab. To join by telephone, dial 833-568-8864, toll free. Once again, that phone number is 833-568-8864. Then enter the webinar ID 161-990-8039. Once again, the webinar ID is 161-990-8039. If the first phone number does not work, please try another. There are more listed on the meeting agenda. If prompted for a participant ID, press pound. Detailed instructions for using Zoom are available at monterey.org/public meetings. To provide public comment via Zoom, please use the raise your hand function at the bottom of the screen. To provide comments by phone, dial *9 to raise your hand, then *6 when called upon, to unmute when called upon. Public commenters will be announced using their last 3 phone number digits or the name typed into Zoom. Public commenters will be muted until it is their turn to speak. Please turn off TV or computer speakers or go to another room while connected, as background noise interferes with the broadcast. Public speakers will be called upon in order of hands raised. There is a 3-minute time limit for today's meeting, so please stay within that limit. And lastly, our chair has requested that we alternate between video and in-person public comment.
Great, so for public comments at this time, if there is anybody that would like to make a public comment, you may speak for a maximum of 3 minutes, as Jennifer said. And it's on any subject which is within the jurisdiction of the Monterey Planning Commission and which is not on the agenda this evening. So anybody like to speak? Jennifer, any hands raised?
I do see some attendees watching, but no hands are raised at the moment.
Okay, we'll move on to our public hearing. And we are considering item number 5, which is consider recommending an ordinance, to the City Council repealing and replacing City Code Chapter 38, Article 17, Section 112.4 related to wireless communication facilities. This is exempt from CEQA. And may we have staff presentation?
Thank you, Chair and Commissioners. Tonight represents the 3rd public hearing on the proposed wireless ordinance. The first hearing was back in April. the second on August 9th, and tonight is the third hearing. Our recommendation is the Planning Commission adopt a resolution recommending the proposed ordinance to the City Council. At your last meeting, I gave a complete historical background of where we started on wireless approximately in 2018 and where we are today. I do have those slides, so if you need me to go back through the history, I'm happy to do that. But I thought it was more important to focus tonight on what's happening since August 9th. At the August 9th Planning Commission meeting, the Commission's motion was to continue the item to tonight, September 13th, to allow staff to do an analysis of the staff subcommittee draft and compare it to the current proposal and to respond to recommendations on a point-by-point basis. So you wanted to understand the difference between the subcommittee draft and the ordinance that's being presented and explain which recommendations were added to the ordinance and why. Attachment 2 to your staff report compares the subcommittee draft and line out, strike out to the draft ordinance presented to the Planning Commission. There's been 90 footnotes added in, or endnotes, if you will, explaining the differences and the reasons why the changes were made. If you have specific questions about those changes, we're prepared to respond to those questions. The second part is after the Planning Commission made their motion on August 19th, Commissioner Brassfield indicated that he would like to submit additional questions to staff and obtain specific answers. Even though the commission didn't formalize that in their motion, there was sort of a general concurrence that Commissioner Brassfield could independently submit the comments and a request for us to respond to those. And that's included in attachment 3 to your staff report. I personally think Commissioner Brassfield's comments did a fairly good job in capturing some of the community's questions that we've received in over about 100 pages of public comment. So I thought it would be helpful for me to highlight what I think are sort of the key policy questions that are brought up. Of course, we can our team's prepared to respond to all of them in more detail if you'd like. One of the key issues that keeps coming up is a wind safety test. I want to let you know that both the subcommittee draft and the proposed ordinance require a structural analysis by a qualified and licensed engineers to be submitted as one of the application requirements. We removed, or the specific mention of wind load analysis was removed in the proposed ordinance because it need not be mentioned specifically. All analysis required to demonstrate that the support structure will be safe will have to be performed and included in that report. Noise creating equipment post-application. So the subcommittee draft and the proposed ordinance require applications to include a noise study to ensure compliance with the city's noise ordinance. The only exception is if the proposed facility does not contain equipment that generates noise. And sort of if you keep reading on in this comment, the concern was, well, if the original facility didn't generate noise and they propose amendments to that facility and the new facility generates noise, that there was concern about that. And so the use permit process will ensure that the Planning Commission will have the noise report as part of the consideration of their application. And in fact, pretty recently we experienced this. 600 Hawthorne, they proposed an emergency generator to support the existing facility. And we had a noise report in that document, and the Planning Commission discussed the noise impacts of that facility. The difference from today's ordinance is 6409 applications don't currently have the requirement to submit a noise report. So this would be the proposed ordinance, the subcommittee draft and the proposed ordinance would be more stringent than exists today. RF reports. So the RF compliance report submittal requirements are the same in the subcommittee draft as in the proposed ordinance. We did add a requirement that the RF report be signed under penalty of perjury. And this was one of the comments by the MVNA Neighborhood Association we received. I do want to point out that that addition we made to the ordinance, Verizon has objected to that addition. It's in their letter stating that it was excessive and should be deleted because the section would already basically be covered because the licensed engineer would have to stamp the RF compliance report. So under penalty of perjury was seen as something beyond. We think it's something we can require, and so we added it to the proposed ordinance. So there was quite a bit of text, predominantly in the MVNA letters, saying that there should be more guidance for the RF reports. And we do want to point out that the FCC has produced guidelines. They're in this bulletin, OET bulletin number 65, that serve as the basis for the proposed report requirements. Our legal teams have reviewed and compared the language in comparison to the MVNA comments, and we don't find that it's more stringent as compared to the proposed ordinance. Broad requirement to include the calculations and information on which the engineer relied. And the conclusion is that the additional detail proposed by MVNA would not materially change the report and may actually limit its content. This is a big issue that's really come up predominantly post subcommittee. Sometimes it was talked about, but both the subcommittee draft and the proposed ordinance didn't include drive test data. This is really something that we're seeing in the last several months. And so it's very important to discuss this issue of claim of prohibition, effective prohibition, or significant coverage gap. And we have attorneys online that can explain case law in more detail if that's helpful. So first of all, the Planning Commission will weigh the evidence for effective prohibition. And basically, we can anticipate that the basis for effective prohibition complaint will vary. It's going to be different for different types of facilities. And so too will the evidence that supports their claim. And so basically the subcommittee draft and the proposed ordinance do not mandate the type of proof, but rather require the applicant to provide all the facts that it relies on for that claim. And then before I go on, I do need to point out that under the federal law, and there was a Ninth Circuit decision upholding the FCC small cell order on effective prohibition, an applicant for a small wireless facility may choose to submit proof of a significant coverage gap, but the city may not mandate proof of significant coverage gap for that application type. So we can't mandate that that be submitted. In the subcommittee draft proposed ordinance, applicants are encouraged to provide coverage maps and other listed information, but it's not a requirement. It's going to be incumbent upon that applicant to prove to the Planning Commission about this effective prohibition. So what does the ordinance include about? It basically says that applicants who claim the denial would be a prohibition or effective prohibition are encouraged to address at least the following. This is the recommendation. If the contention is that the compliance with an aesthetic standard is not reasonable, they need to explain why in detail and describe alternatives considered in determining whether the service objectives for the wireless service provider could be reasonably satisfied by other means. Second of all, what existing or planned personal wireless services the affected wireless service provider would be effectively prohibited from providing if the application is denied. So what is going to be not provided to the community? The factual basis for any claim that denial will substantially impair a wireless service provider's ability to provide a personal wireless service and the information relied upon in support of that claim. Number 4, the factual basis for any claim that denial would result in a prohibition or effective prohibition under applicable precedent in the United States Court of Appeals for the Ninth Circuit Court, and the information relied upon in the support of that claim. And then the 5th we are recommending that current signal coverage by providing maps showing existing coverage in the area to be serviced by the proposed facilities, including areas outside the city if it's applicable. In order to be treated as prohibitive, maps shall be dated and based on data collected within the prior 6 months or less to reflect all facilities installed inside and outside of the city as of the date of the application that may affect coverage. So I think this is a really important point, and I expect you'll probably have questions about this, and we can come back to it if you do. So there's been, when we started this project with the subcommittee, we basically started with the MVNA draft ordinance, and then we held meetings on that through the subcommittee, and that's, a revision of that is before you today. There's a relatively new attorney from the East Coast that's been participating in sort of regional discussions on this issue. And he's created a YouTube video recommending more detailed and stringent language. And I think it's important to point out, we did review the video. Mr. Campanelli's advice on significant gap test is principally directed to jurisdictions in the Second Circuit, and it's not pertinent to jurisdictions in the Ninth Circuit, which includes California. So we have different circuits coming to different conclusions on the significant gap issue. And basically in the Ninth Circuit, the court upheld the FCC's interpretation of effective prohibition in the FCC small cell order. And no other topics Mr. Campanelli discussed, in our opinion, merited changes to the proposed ordinance. So a lot of questions about website posting. So both the subcommittee and the proposed ordinance require website posting. I'll let you know it's more than we do for any other applications we receive. Today, under the current ordinance, we post the major submittal requirements that are received. The proposed ordinance goes substantially beyond that. It says, except where good cause has been shown as determined by the director, applications will be posted on the city website within 5 working days of filing or soon thereafter as practical, along with communications between the city and the applicant regarding those filings, including additions and modifications to the filings. The city shall post notice promptly when the application is deemed complete. The city's failure to post the applications by the time required shall not affect the validity of any application submitted under this section. The subcommittee draft included 3 working days. I'll let you know that's just not practical for our staff. We can't turn around everything that's submitted. Sometimes there's holidays. Sometimes I have employees out sick. There is not enough administrative support to turn it around in 3 days. I think we can turn it around in 5 days. And to be honest, it's really going to be stretching our staff resources to do it within 5 days. An application submitted on a Friday, that's Friday, Saturday, Sunday, Monday, Tuesday. And that's really challenging with our current staff levels. In addition, this new ordinance requires to post all communications. So we're going to have to start saving all the emails back and forth, and there's all sorts of emails that go back and forth, what does this mean? What does that mean? And just trying to get clarification on an application. So there's a lot more administrative work. We believe we can do it within 5 working days. So minimum setbacks from residents and schools, the subcommittee really didn't talk about this. This wasn't a key issue brought up. It's a more recent issue. And I'm going to give you our conclusion first and then show you a map. So we had a GIS map prepared that showed if the city were to impose a 250-foot or greater buffer from schools and residential properties for wireless facilities in the public right-of-way, this would eliminate large portions of the city's streets from any wireless placements, even in areas where placement in the public right-of-way is otherwise preferred. And this could pose legal challenges to the city. So I think if you read the letters, they talk about a 250, 500 and 1,000-foot setback from all residential properties and schools. And so the least restricted, at 250 feet, not 1,000, you can see that basically it's going to be very limited where you can install wireless facilities in the city of Monterey. And there's legal cases and decisions around this issue that Gail Koresh, our attorney from BB&K, can elaborate on for you. But there is something you could consider. So we don't think you can say 250 feet from every house in the city of Monterey, but we think you could require setbacks between cell facilities. And there was a question, 300 feet or up to 1,000 feet. So the FCC has recognized that spacing and setbacks based on a concern about aesthetics may be justified if they're reasonable. And we couldn't figure out how to do a mapping analysis to show every light post in the city of Monterey and what 200 or 300 or 1,000 feet would look like. But you may want to consider a modest spacing requirement between facilities to avoid clutter. I think one of the questions I have in my mind that I can't visualize yet, we have 4 companies deploying systems in the city of Monterey. So right now we have 1 PG&E. We're going to have 4 companies all trying to do the same thing, all trying to install very similar systems. How is that, 300 feet from every facility? How is that actually what's that going to look like as it's deployed in the city of Monterey? I'm not sure, and I'll just put that out there. So this isn't something that's been considered. You can require it. I'm not sure if it's a good or bad thing yet in my mind. I haven't been able to come to that conclusion. So those were some of the key issues brought up in Mr. Brassfield's matrix. It's not all of them, but I think it's a good summary of some of the key issues. I also wanted to explain that the ordinance attached as Exhibit A to the resolution is a line out strikeout version from the one that we did on August 9th. And the reason we did that, we caught additional things we wanted to tweak in the ordinance as we were going through this exercise, preparing for this meeting. So I think, first of all, you'll see most of the red lines mainly reflect corrections to typos and cross references. Sometimes the capital S under the lower S. I mean, you'll see there's a lot of those. I think there's 2 substantive changes. There was a recommendation, I believe it was from MVNA, to require a site survey. And as we thought about this more, and I thought about the original application in the MVNA neighborhood. So we basically wrote it, if there's an existing pole and they're going to be putting ground equipment or grading or doing anything around that pole within 10 feet of it, we would like to see the lines and the topos to understand what that's going to be. The application that was submitted a long time ago, they actually were building a retaining wall back, and there was a small equipment cabinet in front of it. So upon further reflection, we think this proposed requirement for a site survey, even in the public right of way, might help us reach better decisions as a city. Okay, and then the last one is regarding the noise. We do recommend deleting the text referring to noise studies for modifications to existing facilities and adding a new condition of approval, making it more clear that modifications require a permit application, which includes a noise study, unless the facility or modification creates no noise. So it's like moving it from one section to the other. Seem to be more clear that basically we will require a permit application and a noise study if they're modifying that facility and it generates noise. So it moves it from one section to the other. So as I wrap up here, what did the city council direct the planning commission to do way back when? I believe it was 2018. is to consider options for strengthening the city's wireless application requirements and make a recommendation to the city council that is consistent with federal regulations. Staff's conclusion is that the city is regulating to the fullest extent based on aesthetics and public health and safety allowed under the law. And with that, we're recommending the Planning Commission recommend the resolution to the city council repealing and replacing the city's wireless ordinance.
Thank you, Kim. Are you complete? All right, questions for Kim?
I have
Sandra?
just one question. I went through the three primary submissions from the public. One was a group letter that came in via email. One was the one recently submitted by Sb9, and one was the one from the MVNA from Jean Rash. And I identified 10 primary issues that they bring up relative to this very long ordinance. And you've mentioned all of them except for 3. And you have a comment on all of them except for 3. And so I just thought I'd mention the 3 that I picked up and see if they somehow fold into something you've already said. One was administrative permit for temporary cell phone towers. One was mock-ups, and one was PC oversight on submittal forms. Those are the only 3 that you haven't mentioned, that were mentioned in these community letters. And I wondered if you would have something to say about those 3.
Sure, I can. So mock-ups. The current ordinance for new facilities require mock-ups be installed. It has been very challenging. We had the residential care facility next to the freeway. You might remember, it's
Oh, yeah.
the multi-story building. They had to get fully engineered like small little wood boxes to screw in on the building and to install. And with full structural engineering, full building permits, because we can't have anything falling off a building or a pole on people, obviously. So at the last meeting, I heard MVNA clarify that they would be okay if the mock-ups were placed somewhere in the city, but on the ground. So one of the challenges I'm having at a staff level, and I think the city has, is where are we going to put these mock-ups? We have, I mean, just looking tonight, we have equipment boxes. Some of them range 9 to 10 feet big. So they're going to be large pieces of items that are going to need to be displayed somewhere. They're going to have to be secured somehow. We're ultimately going to have to figure out how to get them removed. I mean, let's think maybe we put them in Via Paraiso Park. We fence off part of the park and we put everything there. Or somewhere else in the city. And from a staff perspective, we don't find that particularly helpful. The facilities are typically high on a pole or high on a building. And we think the visual representations that are submitted do a better job of providing a visual accounting of what that facility is going to look like as it's installed. If the Planning Commission goes forward with that recommendation, we will be bringing up to the City Council the administrative burden to administer that section of the code. And how, are we going to have to go out and measure the equipment to confirm that it meets the size that's being proposed? There's a lot of work that's going to go into mock-ups. And from a staff perspective, we don't see the advantage from a technical standpoint. What was the other one, Sandy?
There were just the 3. One was administrative permit for a temporary cell phone tower. In other words, instead of going through a planning commission permit process, there'd be administrative permission for a how can you be so sure it's temporary?
So first of all, the city does issue permits for temporary installations pretty frequently. Pretty benign ones include things like tree lots, temporary events. The ordinance, when it was being debated, the discussion is what happens if an event comes into the city or something that needs a temporary facility to serve the people coming into town. And we have some really large events that come to the city that so far they haven't needed. But to allow people to adequately have service during certain events, it could be anticipated that we might need a temporary facility, maybe. And I guess I don't want to use any specific event's name because it's not like they're proposing that.
I was thinking maybe if the Pope came back.
Yeah.
Auctions, right?
That'd be a big problem there.
So the idea was that we could give an administrative permit for a shorter period of time, 30 days, 20 days, 10 days, to be able to serve that event. And so that's what it provides. And then the third item,
The third one was PC oversight for submittal forms.
I thought the ordinance required planning commission to approve the submittal form, but that we had ability on an individual application basis to decide if something didn't apply or didn't make sense. And I'll give you an example. Generators. I mean, if you look at our submittal requirements, it goes, we don't have a requirement specifically for generators, nor did we ever we just receive an application for a generator. So like we don't have to get RF reports for a generator. It doesn't make sense. So that's why we wanted flexibility to be able to look at the application and decide if something didn't apply in a particular case.
Thank you. I think you've summarized the primary issues in detail.
And I will go back and check to see if we said the submittal checklist in whole doesn't need to come back to the commission. It's been a while.
Yeah, I have a few questions. You put up one word of exhibit A. I don't exhibit page number. Sorry.
That's the biggest mouse I ever.
Let me just pull up the packet.
Gary, you're coming across muffled.
Oh, sorry. That's because I'm wearing a mask.
Is that the one that's marked up or is it the other one that's clean?
It's the thing.
Thank you.
I just have a couple of questions about language and
No problem. I'm sorry. I should have pulled up the packet as a whole and so you could look at language, but I can do that right now. Sorry, it's just going to take a moment to load and there it is. What page was it of the packet?
page 24.
Thanks. Sorry, it's still loading. Was 153, Chrissy? I believe so. Okay. Let me get this.
50 what?
It was page 24.
Yeah, page
Exhibit A.
24.
I have 28.
Exhibit A.
Correct. Exhibit A.
Okay, it should show up in just a second here. You know why, Jennifer? Is it
Well, there it is. It's on the screen right now.
not on there though?
Oh, I don't know. I'm seeing it on my.
Oh, there
I
it comes
did
up.
mine.
Sorry, it's warming up. Okay,
Okay, so down at the so the bottom of the page is E. So there's this whole discussion of sort of towards the top, like B and C in that area, non-residential building, it moved.
I did it. Sorry.
Non-residential building mounted facilities. So I'm thinking about our application we recently reviewed, where it's not residential occupancy, it's a commercial occupancy, but there are people living in these spaces. So I just wanted to, I was wondering if these sections that talk about non-residential building mounted facilities should, whether, a hotel is included in that.
Okay, so first of all, I should just talk about what this section overall is doing. What we were trying to do, and as you go up before this, we were trying to define by area. So like commercial areas are preferred, like the most preferred. And actually hotels are in commercial areas, so they're preferred locations for wireless facilities.
Yes, I understand that.
And then industrial areas. And then what we were trying to do in these sections is say, here's the general area, and this is our order of preference within that area of where these facilities should be located.
Right.
So in this case, if the provider shows that she'll be permitted to place a wireless communications facility in a non-preferred area, for example, like a residential neighborhood, that's
Right.
something it's not preferred. In fact, our ordinance even, I think, uses the word prohibited.
Yeah,
If it has to go in the residential neighborhood or a non-preferred area, what the ordinance is saying, placement in existing towers off public right of ways or on similar large vertical structures such as water towers or within or upon existing structures in a stealth configuration. That's
Okay.
the first preference.
Right.
The second design preference is non-residential building mounted facilities with rooftop mounted antennas. So if we have in a non-preferred area, if we have a non-residential building, it says put it on the roof.
Right.
If you can't put it on the roof, then let's look at facade mounted on a non-residential building. Because once again, we're trying to say, don't put it on residences.
What about buildings that have people living in them that aren't residences, like a hotel? How does that figure into this sort of the language here? Is non-residential mean anything but a single family residence? Or I guess apartment buildings and hotels, how do they figure into this language that's being used?
So those would be non-preferred location. So hotels are different. So hotels
commercial.
are in commercial districts and
Right.
they are a preferred location
Okay.
for wireless facilities. In
Okay.
fact, most of our wireless facilities today are either on the Marriott or the Portola,
Right.
and they
Right.
have been for a long time.
And they seem to be they work pretty well as far as, everybody's goals.
They've worked well, I think. I mean, visually, we don't have like a lot of communities, those super big structures scattered all the way with, big monopoles with things hanging off them. I think it's visually disguised them.
Okay. So I guess my question is really semantic. So non-residential,
Trying to think of a non-residential structure. Maybe, for example,
Hospital.
if we have a
Mhm.
park near a residential area and we have a non-residential structure, I'm just trying to think of Jack's Park or, maybe it's better to put it on a building in that park, maybe on a bathroom or something, although those tend to be lower,
right.
than getting it close to the residential neighborhoods. It's like the ordinance, the whole goal of this ordinance is to it clearly express the community's interest that these are not located in residential neighborhoods.
Okay.
And if it's got to be there, trying to, get it as far away as we can possibly do that.
Okay. Well, that's fine. I think you've explained it. My main question was semantic, really, about non-residential. Exactly. Because, in building codes, residential has very specific
Mhm.
meanings, but, okay.
What about mixed use? What about mixed use, commercial on the ground floor and residence apartment in the second story? Is
So-
that residential or?
So the preferences as expressed in the code, and I'm pulling this up. The preference is city-owned or controlled parcels outside of open space districts, residential zoning districts, which this code defines as RE, R1, R2, R3, and PC zones not governed by a specific plan. So that includes Skyline Forest in our upper neighborhood. This ordinance encourages wireless facilities in our mixed use areas. And so in our commercial areas that have mixed use housing in them.
Sure.
So that would be the downtown, North Fremont Street, Lighthouse Avenue, Cannery Row. Our ordinance prefers them in that area versus Casanova Oaknall neighborhood versus Laguna Grande versus Alta Mesa versus Monterey Vista. It's like trying to not to first of all say, please locate in our commercial and industrial districts. Actually, I think it's industrial, then commercial.
Okay.
And then after that, city-owned parcels. And then if they start to encroach into our non-preferred areas, we say within those areas where we want to see them first. Now, of course, they're going to have to show effective prohibition to locate in those areas.
Okay. Well, great. No, that's a great answer. So next question is on page 25, just the next page. So 10B. So I guess it's really all of these A through D are all the same question. Effective prohibition showing. And I was wondering if, that's a legal term that isn't clear to me. And it might take a little bit of extra explanation somewhere, either in definitions or something, because it's a very legal term. And I don't know exactly, I can kind of guess what it might mean, but maybe can you discuss what it actually means?
So basically the wireless provider. So first of all, what this section says in our historic districts, you've got to show an effective prohibition. That's not where we want to see these facilities. In our residential districts as defined, you have to show an effective prohibition. That's what the main, it's like, those are places we don't want these facilities as a city. And so clearly communicate.
And yet we have to have them there.
Well, maybe. And they're going to have to prove to the planning commission effective prohibition. And that was what I was trying to explain earlier with those slides. The carriers are going to have to come to you and explain why there's an effective prohibition to their service in that area. And we expect the evidence for that to be varied. And there's been a lot of discussion about significant gap maps, as you saw by the Ninth Circuit. We cannot require those, but we can suggest them. They are going to submit data to the planning commission, and the planning commission is going to decide if they've proven effective prohibition under the Ninth Circuit Court ruling. And I don't think this is going to be easy for us. I mean, I think this is going to be challenging, but it's incumbent upon the carrier to prove to us that they basically have to have a facility in this particular area to provide service.
Okay, so
Can I cut in here?
please do.
Your question, as I understand it, what you're saying about effective prohibition is that we cannot require them to show a significant gap coverage in order to get a permit. However, in determining whether or not there's an effective prohibition, one of the things we can take into account is evidence as to whether or not there is a significant gap in coverage. It's just one of the many things that we would take into account.
I'm going to ask Gail Koresh to be able to, because there is a ruling that if she could clarify, Gail, if you could unmute yourself and I'll try to.
Sure. Good evening, everyone. I'm Gail Karish, your outside legal counsel on the wireless matters. Let me start by first saying the reason why we put in effective prohibition, or that would show would prohibit or have the effect of prohibiting personal wireless services, and we don't define it, is because that we use the language in the statute, the federal statute, which is constantly sort of being interpreted by the courts and also by the FCC. So rather than fixing your ordinance on a particular interpretation of that language that may be the current law, to make your ordinance stand the test of time, we just refer to what the federal law says. And it will be in each instance, depending on the type of application and what the current state of the law is, the carrier is going to have to demonstrate an effective prohibition under the current state of the law. With respect to the showing a significant gap, the FCC small cell order was the order when they were speaking of small wireless facilities, at least in the way we interpret it more narrowly than maybe the industry would interpret it. When they were speaking about small wireless facilities, they said that old test that the courts had developed of significant gap and least intrusive means, that might not be relevant. So you can't require that test for, or that demonstration of proof for an application for a small wireless facility. The FCC didn't say that a carrier couldn't offer that proof. They may want, that may be the route that they want to go to prove that they have an effective prohibition claim, but local jurisdictions can't require that proof for small wireless facilities. But if there was a macro facility, then that would be, in our view, a different matter, that the small cell order didn't touch on what proof should be required to prove an effective prohibition for a macro cell facility.
What you're telling us in English, in plain English, is that they can offer proof of gap in coverage if they want to, as grounds and evidence of why they should get a small wireless permit, but we can't use the absence of that against them. Is that basically?
That's right. But they still would have to demonstrate somehow.
That's almost English, yes.
Yeah.
Thank you.
It's a very complex area of the law, so I appreciate the plain English versions.
Our draft ordinance did not define it by design, as Gail is explaining, because the law fluctuates so much. And our ordinance, I'm trying to put my finger on the exact page, but it does say an effective prohibition is as the Ninth Circuit tells us what it is. And that gives us the flexibility to stay current with the law on its application to the particular facts presented to us on any given application. So
why do we put the Ninth Circuit in?
Pardon?
Why do we put the Ninth Circuit in?
Because
Why do we even mention the Ninth Circuit? What if they're overruled by the Supreme Court, as they are 70% of the time? You know, I mean, no, seriously, why not put applicable law as opposed to Ninth Circuit?
I'll have to find the exact sentence. I believe it covers all of that of what you're saying. I just can't find it right away. But my point in making the comment was that by design, we did not define significant gap in this ordinance, and we don't recommend doing that because it changes like the wind blows potentially with different court actions. And we're bound by the ones initially in our circuit, unless there is a Supreme Court ruling, and then we're bound by that one, obviously.
Okay, great. Thank you. The real, I guess it's the phrase effective prohibition showing. You know, I guess it's the showing that's throwing me. I understand kind of what it means, but I was wondering whether there's another word besides showing that would be better in that, you know, all four of those, you know, ABCDs.
A checklist.
Demonstration or whatever is, are you happy with that phrase effective prohibition showing?
I guess I would ask Gail, is there flexibility to change that from showing to another word?
Yeah, I think so. I mean, if you like demonstration,
Is show a particular legal phrase that's the correct one?
I wouldn't say that there, you have to use the word showing. I think that was, I believe that was the word that was in the draft, even the subcommittee draft, if I'm remembering correctly. I think it was in the subcommittee draft, but I may be misremembering that.
Well, I mean, maybe you'll just review those words and see if there's something better. So I don't want to drive us crazy on this one. The next one is also on page 25. I think it's the same answer, that the eligible facilities, I don't really see that term defined anywhere. Maybe it's the same reason. It's G on page 25.
Yeah, I gotta figure out where my.
An eligible facilities
What?
request is a defined term.
Okay,
So is that another something that we want to just not define it because it'll cause more trouble than it's worth?
Well, it
I don't know.
actually is it is in the definitions,
Oh, it is.
with a reference to the federal regulation that
Actually,
provides the definition.
But I
It's
still didn't
on
understand it.
page 33 or
Yeah.
There it is.
page 1.
I went looking for my copy of
Yeah.
that book and it was in the laundry, I think. So
So the definition right now in I just pulled it up. Eligible facilities request means the same as defined by the FCC and 47 CFR section and as may be amended. So it is defined.
well, maybe you could just explain what an eligibility, I'm sorry, what an eligible facility is, because I don't understand.
So those are the 6409 applications that you're looking at,
Okay,
as I understand it. So it's those criteria that we went through today
right.
is an eligible facilities request.
And you're happy with that language being, it's an industry kind of a term that relates to the specific sort of documentation.
I mean, I don't think the FCC or anybody's made this easy for local planners.
Yeah,
I'll just be
okay.
honest. I
Yeah.
mean, we're using their definitions.
Okay.
Yeah, we don't want to invent our own.
No, that
definition
all,
of the eligible
actually, the more
facility.
you talk about it, the more sense it makes.
Mhm.
So my next question is on page 29. On ongoing compliance.
Okay, just wait one sec. Transfer. Oh, I'm in. Is that, and that's at the clean ordinance? version?
Yeah, the clean ordinance,
Okay.
sorry.
No, it's okay.
We were there a minute ago.
Yeah, I went down to the line out strikeout for some reason.
Uh-oh.
oh,
It's
there's
page
those bubble again.
158, Kim.
Thank you. 33, 37. Ongoing compliance.
There we go. Okay, so the this ongoing compliance paragraph is great. And the question is though that so let's say somebody decides that this sort of third-party testing needs to happen. Is it described anywhere what that process is? There a complaint received or the staff? How does it happen procedurally?
So this enables that to occur,
Yes.
the testing. I think you'll see in community recommendations, they would like the city to have a regular program where the city council allocates money. We hire, I guess, an RF engineer to drive around and to take readings. If city council chooses to budget for that as part of their budgetary process, this will enable us to go out there and do these types of inspections. There's nothing in the code that says that if we receive a complaint, we shall do it. But it does enable that we may do it based on complaints. So if the city council wants to budget a lot, I think it's going to be a lot of money, maybe, I don't know exact, but some amount of money that we could do an RFP for, do that, and then that's their decision. And we would, have results.
Great. Okay. I know Mike Brassfield in his little thing talks about, NIP money, or there'll be some way of funding that if the city decides to make it a priority, I guess.
So if the city chooses, there's a lot of competing priorities, but if the city establishes this as a priority, then the city could go out and do that
Okay.
testing.
So,
Gary, that was CIP, not NIP.
oh, okay. Sorry. So, drive test data.
Yeah.
So that you went through that as part of the sort of the stuff that people are unhappy with. But I can figure out, I guess drive test data is basically you drive by with instruments and try to figure out our RF level.
So as I understand it, and I think we've actually received quite a few comments on this particular point. For the effective prohibition showing or demonstration, some members of the public would like us to require test drive data from the carriers as proof to you that an effective prohibition exists. And our ordinance basically says they have to submit evidence, and you're either going to you're going to weigh it, and you're going to decide whether or not they show an effective prohibition. We think that's a stronger point than requiring things that maybe they can't provide, or whatever the answer is to that. And Gail may be able to expand on that, but I think we just explained we kept that broad based on the legal, whatever the courts say, so we can have the best evidence in front of you about what's required for an effective
So
prohibition.
drive test data would just be one form of evidence.
They could submit it.
Yeah.
And I think you'll remember, I'm sure you do remember, those of you that were on the commission, the public went out and submitted a video and they called and they said, we have cell service,
Do you hear me now?
we have video service, I can hear you. But that's not going to be the only measure of effective prohibition. It's going to be, how long does it take to download? And probably a lot of things I'm not even thinking about, that the industry is going to come to you and say, there's an effective prohibition based on why. And you're going to have to weigh that and decide whether or not to allow the facilities in discouraged/prohibited areas.
Okay. Thank you. I'm almost done here. So the next question is about mock-ups. So in a world without shot clocks,
Yeah.
the planning commission could require an applicant to provide a mock-up.
Well, even with shot clocks, I mean, it can be a submittal requirement that an application won't be deemed complete until the mock-up is installed and submitted.
Right.
I am saying that it is a substantial hurdle to build something. We're going to have to figure out where to put it, how to store it, how to protect it, how to get it removed. So I'm assuming, what happens if someone just leaves it, I don't know, in a parking lot or a park that we've designated. The public's not going to want to see that there forever. And then we're going to have to get it removed. It is a lot of work to make all of that happen.
Yeah. And you don't have room in your office.
We'll make it put them on.
Okay. So, it's just that it seems like, that the whole mock-up thing, it's basically a case-by-case situation. Probably 99% of the time, a photo montage is fine. Sometimes, sometimes it might not be. It'd be, I guess, like we had, on another application, there are periods where, God, a mock-up would be great, but the shot clock is breathing down our neck and we have to get the applicant to agree to it. Because a mock-up would be,
Yeah, I'm not sure I see a problem with the shot clock, really. And
Really?
if it's required to make the application be deemed complete, then it's required. For me, it's more of, making sure that that they're installed. I mean, it's what I described. It's that whole, if they have to build something and bring it to the city, and then we're gonna have to store it, and then we're gonna have to get rid of it.
Well,
There-
my point is that in 99% of the cases, the photo montages are fine.
Well, and that's our conclusion
Yeah,
as staff.
the 1%, it would be nice, I think, so the PC could require mock-ups on a case-by-case basis.
I don't think so.
Oh,
So I think once the application is complete, you have to process it in 60 and in.
Can we cross that bridge when we come to it, please?
okay. Let's see, so my last question is so there was a letter from Gene Roche about the district court in the East District of New York case about the village of Flower Hill and all that. I guess that would be Christine's. Did you read that letter?
Which letter?
It's July 27th, 29th letter from Gene Roche.
Second district court
Oh,
decision.
I'll defer that case. Gail, did you that?
Okay, fine. So that's all I have. Thank you.
Here, we can let Gail comment.
Respond to that.
Gail, do you mind responding?
Sure. So I don't have that letter right in front of me, but as I recall, it was arguing that you could you could require significant gap analysis. Was that what it was arguing, or that
It's the wrong circuit.
the
court.
point I would make about that letter or that case is basically standing for principle that if you are a lower court in the federal court system, you follow the precedent of your circuit court until it changes.
Right.
So that court was following the precedent in the Second Circuit, and the Second Circuit had determined the plain language interpretation of federal law, and it hadn't considered the FCC small cell order yet. But because we're in the Ninth Circuit, where the FCC small cell order has been upheld with some exceptions, there were some parts of the order that were not upheld by the Ninth Circuit. We're any district court in the Ninth Circuit would have to follow the Ninth Circuit precedent, which includes having upheld the effective prohibition discussion in the FCC small cell order.
Great, thank you.
Well, first of all, Terry got a lot of the questions I had answered. One of the issues that was in that questionnaire I prepared, I put in there regarding a cautionary statement, and I'm a little hesitant to go into this now, but I will. In the case of cell towers, the evidence system is turned around from a normal concurrence. We have to prove. It's not a matter of them proving it. We have to prove and follow along with what the FCC interpretation of the order by Congress has done. So that puts us in a dichotomy here. We're going against some of the 200 odd years of jurisprudence that we're having to prove our case instead of them having to prove the case instead. So the people are not being heard on this issue, and we're stuck. I'm sure everybody likes sausage of some kind. If you've ever sat in a butcher shop where they made sausage, you would not have the same thoughts on sausage. It's not a pleasant process. And that's what we're going through right now. We're being forced to take a position to support our citizens in many cases that the law doesn't allow us to take. And the frustration I'm hearing from the public. So one of the things I suggested is that we write a cautionary statement talking about these issues, that this is a local issue that has been magnified into a national issue. But we have concerns that they refuse to recognize, and that's the health issues. And it was explained to me, as you saw, that the city of Monterey can write up a letter of protest and put it out. Back when I was working, I used to call that fluff. You can characterize an issue and it just, you get to feel good because you put it, but it goes nowhere. Well, every time someone comes and looks at our ordinance, my intent was that they see a statement that we don't like this, we don't like what was being done to us, so we're going to offer a cautionary statement. So that if later on it comes down, some other action comes down, our people have been heard. Our citizens, our neighbors, the fact that we've done multiple hundreds of hours on these hearings shows the distaste of our local citizens on this issue and the fact that we're going through this process. Now, I personally, I would like to see that cautionary statement in there because I think it shows a position over and above some fluff statement sent out to Cyberland. Thank you.
Okay, Stephen, you're the last one. Do you have any?
Can I just respond to that real
Yes, go
quickly?
ahead.
So
I didn't
on
hear a question
page-
in there.
packet page 229, there's an example cautionary statement. And what we say in response to that is the city can, and we have, our city council has adopted positions on other issues as they've come up and said, we don't like this or whatever. And the most recent one I remember was on gun control in relationship to the school shootings. So there is we wouldn't see that typically in our ordinance, but the city council has adopted, I believe it's a resolution expressing their thought on something that they're seeing nationally or something like this. So it is possible to adopt a resolution acknowledging whatever the city wants to regarding like this cautionary statement or something.
But who sees that, Kim?
I'm sorry, what?
Who sees that?
Who sees it?
Yeah, who's it addressed to?
They are posted, I believe, on our website as
Yeah.
advocacy letters. The city council could choose to send their position. I think the gun control one was adopted in unity with several cities. Saying, you know, we would have issues with gun control.
That's exactly why I'm suggesting we write it and put it in the ordinance, because the people who are coming to us, and it's not as benign, if a contractor wants to put in a cell tower, he can do it by going through the process. And it may not be at the instance of a company. It's sometimes pure profit. So what I'm just suggesting is that when people come to our ordinance and they see that we're putting in a statement in there that we're doing this under protest, that's all I'm asking. I have heard too many people make these comments at too many of these hearings. And I agree with them. We can't do what they ask. They ask us just to plain deny it. We cannot do that. But we have to do what we can, but putting it somewhere else where nobody that is trying to file these things gets to see it does no purpose as far as I'm concerned.
Thank you, Mike. Stephen.
Thank you, Mr. Chairman.
Yes, am I to go?
Yeah.
A little bit of housekeeping. A packet page 170. Paragraph 2.
Just 1 second, please.
Sure.
Okay.
It reads, a use permit may be issued for a temporary wireless communications facility by the community development director parentheses director crossed out, end of parentheses under this section. Then later on, you refer to the director, but you don't say what director it is. So if you mean the community development director, I suggest that we reinstate director, which in parentheses, so that it's clear in the rest of the ordinance who the director is.
I think it's in the definitions, but let me just double check.
I didn't find it.
Good eye.
Yeah, I don't see it.
It is on page 201, Christie.
Is it on 201?
Yeah, so it's in definition.
Yeah.
Community Development Director or Director means the Community Development Director, or Director's designee.
My apologies. I missed that one. The other thing is, looking at the setbacks that you had in the attachment 3, I think it was 250 foot, 550, 500, 1,000. Was that setbacks from schools and R1 housing? Or was that setbacks between the poles?
That was, we did the map a couple different ways. It was 250 feet from residential and school properties.
Yeah.
So,
Okay.
and we actually did the analysis 2 ways. We did one based on the actual lot line. So we considered the whole parcel. We did another one that was just address based. So like a dot within each. And the analysis didn't really change very much.
Yeah, I really thought that was very, very good, and I would strongly support that being placed in the ordinance. The other thing is, I would suggest, leave this to the lawyers, but there be a severability clause. And maybe there is generally in our code, I don't know, but that if one of the provisions of the ordinance is held invalid, the rest still are valid.
That's, it's actually a part of our template that goes to city council ordinance adoption.
Okay,
It's automatically in every ordinance that we pass.
okay, great. And the last thing was, at that time, Chairperson Freeman mentioned that there, in the future, not too distant future, they may be going to satellites, may not even need poles anymore. And I was thinking, you know, what do we do with a company that goes from poles to satellites and then goes bankrupt? How do we remove the poles? And I checked into it, and we can't require a cash bond. I mean, a cash deposit. But can we require them to put in a performance bond that ensures that the poles will be removed that they use in the event that they're no longer in use? Other than that, I would just say to Kim and your staff, you really did a fantastic job. Thank you. That's all I have.
Thank you, Stephen. Did anybody want to answer his last question?
One comment.
Yeah.
I must thank you from the bottom of my heart for the markup on this and the little the footnotes are in. That was hugely valuable. Wish we had done that, you know, a couple of years ago. It would have made it so much easier. Also, to Mike Brassfield for doing that independent work to make it easier for the rest of us.
Okay, thank you, Mike. There are no more questions. Let's take our public testimony on this, and we'll start with members in the chambers here. We're going to be using the 3-minute clock. And if you could state your name, that'd be great.
Definitely. And before anyone speaks, I just want to announce for the public, in case anyone is watching at home or on YouTube, members of the public are encouraged to join our meetings via Zoom Gov, a secure service that connects you live with no lag time. To join the Zoom meeting from a computer or phone, use the link or phone numbers on the agenda posted at isearchmonterey.org. To join by telephone, dial at 568-8864 toll free, then enter the webinar ID, which is 161-990-8039. The phone number to call is 833-568-8864, and the webinar ID is 1-990-8039. To provide public comment via Zoom, please use the raise your hand function at the bottom of your screen. To provide comments by phone, dial *9 to raise your hand, then *6 to unmute when called upon. Public commenters will be announced using their last 3 phone number digits or the name typed into Zoom. Just a couple more reminders, there will be a 3-minute time limit on each comment, and we will be doing our best to switch between the chamber and Zoom, which we do have hands raised there. So please state your name for the record. Welcome.
Thank you. I'm Jean Rash, and I did present this letter from the Monterey Vista Neighborhood Association, but I really wanted to comment on the dialogue and keep the dialogue going. Our understanding is that the City Council directed the staff and Planning Commission and the subcommittee to come up with the strongest protections, not just legal protections, the strongest protections. Let's not forget that. The purpose of my presenting the Second Circuit opinion is not because it's controlling. I admitted that night that it's not, but to show that the rest of the country is moving in a different direction, and maybe we could be part of that. I think we have an unparalleled opportunity to work with Carmel, which is going through the same thing, and get economies of scale and really tackle this together. That's what I wish you would do. If we can't put in the requirements for the probative data, we should put in suggestions as to what we're looking for, that we want drive test data, that we're suggesting drive test data, dropped call records, and significant gap documentation. Because the reason we stopped the 13 is just what Commissioner Brasfield said. The citizens went out and accumulated all the data, and that's just backwards. It should be on the vendors to present all this data. We can't be putting it on the citizens to do that every time. As to having an RF employee of the city or checking the RF radiation, we put the cost on the vendors. We can figure that out. It doesn't have to be on the city. That's part of the application fee. Okay, the mock-ups. Again, we have 28 parks. We have plenty of room. And again, you put that onto the vendors. They have to pay for bringing the mock-ups. They've got to get it in. They have to get it in by a certain amount of time. Disposing of it might be a problem. I get that, but somehow we make it the vendors' possibility. Because look, the members of the commission admitted that the Wave Street small cell tower proved to be surprisingly offensive and cumbersome. That and complaining that or opining against the mock-ups because it's going to take up so much space is proof that we need it, because these are large encumbrances that we need to understand. No one has talked about why did it go to 4 feet when it had only been 2 feet for raising the antenna towers. Lots of other stuff, but I'm sure you'll hear it tonight. Thank you.
Thank you, Jean.
Good evening, Susan Nine, former subcommittee member. I would like, sorry, that's okay. I am alarmed by the misunderstandings about the current state of telecom law that I've heard tonight, especially from members of the Planning Commission. And I can only assume that's because you're not hearing the whole story from the people educating you. Ms. Karish left out the probably the most important part of the Telecommunications Act that deals with this issue, which is the grant of authority, the very first paragraph. And that states specifically, and it cannot be taken away unless they rescind the Telecommunications Act, that you have absolute authority over the placement, maintenance of cell towers, wireless equipment. That law is the law of the land. And the FCC can't change that law. They're not a part of the judicial plant. They can't interpret the law. The courts do that. That section of the Telecommunications Act also makes very clear that the only way that they can upset that right of authority over placement is if the applicant can establish an effective coverage gap or an effective prohibition, which the courts have interpreted that way. And so to hear a member say that the responsibility is shifted to the Planning Commission to prove them wrong is such a gross misunderstanding of the law. It takes away all of your power. The telecom industry and many lawyers are connected with them are systematically trying to get you to drink the Kool-Aid that your hands are tied. That is far, far from the case. I've heard so many errors made of very important things that you need to understand how powerful you are. It's a constitutional grant of authority as well. And you have responsibility for those decisions, not the applicants that come before you. So I think we really need to get straight on that with some seminars or something and bring in some second opinions on the way that the law is being interpreted tonight, because we all need to understand that in order to act in a judiciary capacity as you are called upon to do in hearings. I don't even know where to begin with the details of what's been taken out. The temporary cell tower issue is about noticing people because our committee insisted on noticing people if they're going to have maybe a 50-foot cell tower put next to them for weeks on end, maybe right next to their homes. They could be adjacent to residential areas. There's no oversight. We just wanted people to be notified. What was the reason the staff gave? Quote, the staff prefers no noticing. I'm sorry, I don't accept that this is the best we can do. Thank you.
Thank you, Susan. Can we go to the, Jennifer, can we go online?
Yes, we can. And we do have somebody already raising their hand. And Judy Schmidt, I'm allowing you to speak. You should be able to unmute.
Hi, good evening.
Hello.
Hi. I'm sorry, I walked outside. I'm actually in Southern California and I'm right next to an air conditioner. So let me shut the door and be able to speak and hear you. Unfortunately, I haven't been super involved in what's been taking place with the city and the whole cell tower issue. However, I did make comments back in 2018 because I have horrible cell coverage at my home up on Cuesta Vista in Monterey. And I know that some of the people within this group of people who are against having the towers in the area claim that they did some sort of a testing and said that my service was just fine, which is not true at all. I know that many other people feel the same way. And I'm really curious as to how many people this group, what is the percentage or how many people are actually representing this view or opposing and giving the city such a hard time about this? Because I know, there's a lot of people that just don't speak up, that are okay with it and don't have quite the problem that many people do. And I don't feel that this group is truly representative of all the people in Monterey. So, I'm very curious as to how many complaints you have had from various people from within our community. And I'm just calling to say that I'm for the towers. So thank you and have a great night.
Thank you.
Good evening, Commissioners. My name is Marta Krapchik, and I'm a lifelong resident of Monterey. I am here to request the strongest possible cell tower ordinance to protect all Monterey residents. I would like to call your attention to two important sections of the ordinance that deal with public right-of-way applications. These examples show the draft ordinance before you is not as strong as it needs to be and is less strong than the existing ordinance in significant ways. For instance, the section on extensions of structures and antenna height. The City of Monterey's ordinance currently in force reads as follows with regards to pole-mounted antennas. Pole-mounted antennas shall not increase the pole height by more than 2 feet and generally shall not exceed the diameter of the pole. However, the newly proposed draft language allows antenna height increases of 4 additional feet or more if necessary to achieve separation from electrical facilities. If this is supposed to be a stronger ordinance, then increasing allowable height beyond what has been in place for decades would impact views, neighborhood character, and aesthetics. The ordinance ultimately adopted by the City of Monterey should retain the 2-foot limitation existing in our current ordinance. The second example is in the next section titled Pole-Mounted Equipment Cabinets. The wireless ordinance currently in effect for Monterey reads as follows. When pole-mounted equipment is either permitted or required, all equipment other than the antennas, electric meter, and disconnect switch should be concealed within an equipment cage, not extending more than 10 inches beyond the pole center line on either side. The new draft allows 15-inch deep equipment cabinets on poles with up to 4-inch standoff mounts. This change would almost double the distance equipment would be allowed to stand out from the pole upon which it is mounted. This is not making for a stronger ordinance, but rather weakens what we already have in place. These increases would also result in greater visual impact and blight caused by antennas and pole-mounted equipment at a time when the city should be promoting less conspicuous options. The public, the City Council, and members of the Wireless Subcommittee have repeatedly asked for the strongest possible wireless facility ordinance. This is the third hearing, and the draft before you is essentially the same as presented to you by staff months ago. This is in spite of the commissioner's requests, public input, the requested improvements provided by the neighborhood associations, and samples from other very strong ordinance being drafted by forward-thinking cities in California and elsewhere. Please do not accept anything less than the strongest possible ordinance. Our city deserves no less. Thank you.
Thank you.
Good evening, Pat Benza, Monterey Vista neighborhood. Lost all my notes right before I got here, so I'm winging it here. To get the strongest possible wireless ordinance, it may mean that we need to push the envelope and maybe take some risks as to the hard line of some of these issues. In the FCC document in 2020, they went out and did the drive test and collected data. And yes, it's multiple ways of doing it, and it needs to be specific as to how it's done. But it has shown that in comparison to just saying, show us your data, when they compared it, if it wasn't drive test data, the chances were it was 16 to 64% inaccurate. So how are we going to say that what they're giving us is going to be accurate data if it's not specified that you did the drive test and it included all of these different types of drops and whatever? Okay, it needs to be specific. And the idea that it says denial would result in prohibition, according to the U.S. 9th Circuit, is just so broad. And I know that they're trying not to have to rewrite it all the time, but it definitely is not user or applicant friendly. How many people really know what the requirement is of the 9th Circuit? Terry brought up about the definitions and we agreed. And in the Monterey Vista neighborhood document, we must have added 20 different additional definitions that we felt had to be in there because it needs to be user friendly. And prohibition and effective prohibition were in that list. Also, there was a new Monterey resident here last time for the last 2 meetings who was talking about the cell tower that is up in New Monterey, on Divisadero, somewhere up there, and how it was required to make changes, add, I guess, planting and all to camouflage it. And she said, it's never been checked. The plants have all died.
Yeah.
And so the maintenance is a requirement that needs to be going on. Mock-ups, they're not all up there. The mock-up that we brought in here for the last one, which was just so classy, but it did the trick. People were shocked at the size of it, made out of cardboard boxes, and it did the trick. But they're not up there. All the ones in Monterey were going to be started 8 feet off the ground. That is not a way up there. Okay, thank you.
Thank you, Pat. Mine?
Okay, thank you. And we do have one printer online. There's a phone number calling in. The last 3 digits, 941. You should be able to unmute. Oh, sorry, I think I just muted you.
Good evening, Planning Commissioners. A judge in Clear Wireless versus Lindbrook said, and I'm paraphrasing, it's not up to the FCC to say something in the Telecommunications Act it does not say. You have to remember that phrase. It's not up to the FCC to say something in the Telecommunications Act that it does not say. During the last ordinance meeting, I listened to your telecom attorney. She was basically telling you what you could not do. She stated items such as densifying a network that act didn't even mention. The Telecommunications Act was a compromise between deploying wireless technology while also maintaining local authority over decisions regarding placement, construction, and modification of wireless facilities. Congress would not have left a clause for local control if it did not intend it. You should exercise that control through your wireless ordinance and its zoning requirements. It's very important that you have control. Last meeting, the telecom attorney was referencing an FCC declaratory order, FCC 18-133, and treated it as statutory guidance. It is not. These FCC guidelines represent hundreds of lobbyists' inputs on what they want the wireless landscape to look like. Lobbyists from Singular, Wireless, Verizon, to organizations like Smart Communities. By the way, Smart Communities has been represented by BB&K to enhance the rollout of broadband. Yes, the same law firm you hired. From time to time, courts rule on aspects of these declaratory rulings, and this is what the Portland case did. It ruled on 3 items: fees, aesthetics, and timelines. It did not address significant gaps. And for rules relating to effective prohibition, it said, go to see our ruling on Sprint versus County of San Diego and California payphone. The Sprint case made it up to the 9th District Court of Appeals and basically defined effective prohibition as an outright ban on wireless facilities. You could not say, we will not put wireless facilities within 1 mile of a road, because that's effectively prohibiting wireless service, but you can decide the least intrusive place to put it. You have responsibility to your community to protect your citizens. You cannot allow this weak ordinance to go through. If you don't speak up now, these towers will begin to show up outside of children's bedrooms, and you will have to live with the fact that you could have done something, but you chose not to. Thank you.
Thank you. Back to the chambers.
Okay. Your turn. That was the only last comment
Thank you.
online.
Gina Jett, citizen of Monterey. For the umpteenth time, my neighbors have eloquently, accurately, and passionately outlined the specifics of what is wrong with staff's proposed wireless communication ordinance and how to fix these weaknesses, including an extensive list of definitions. We have informed you and staff of the growing list of municipalities that have updated their ordinances to protect their residents and the integrity of their neighborhoods. We have even given you and staff the names of the attorneys that specialize in developing ironclad lawsuit-proof ordinance based on established case law. For the umpteenth time, we have told you and staff that BB&K is not a firm that specializes in helping Monterey develop the strongest wireless ordinance possible. So after all this of 4 years back and forth and staff's demonstration of blatant unwillingness or inability to ensure a strong wireless communication ordinance, I ask the critical question of the hour. Why do you suppose Monterey still has no strong wireless communication ordinance? I am focused tonight on the why question because I am quite certain everyone in this room understands the technical concerns about wireless communication facilities in our neighborhoods. Let's quit pretending. Paraphrasing an esteemed American writer, Upton Sinclair, quote, "It is difficult to get someone to understand something when their salary and financial gains depend on them not understanding something." This likely explains why many are incalcitrant and dug in. Follow the money. Who financially stands to gain by a weak ordinance? To name the obvious winners, the telecom vendors can expand its market with very few guardrails imposed by the city. The city in turn expands its revenue base through the quick approval of more applications and the leasing of more pole and right-of-way space without being encumbered by a strict and well-defined ordinance. The contracted attorneys participate in the stalling tactics to support city objectives, thus ensuring that the telecom industry gets a foothold in neighborhoods where there is very little that residents can do to protect themselves. Now, that's certainly a lucrative arrangement for the three main beneficiaries. But who does not financially or otherwise gain? Clearly, the residents do not benefit financially or otherwise. Residents are unprotected by their own city and are subject to potential property devaluation, greater risk for urban fire and top-heavy utility poles, and threats to health. Thank you for taking a few moments to ponder the elephant in the room and then devise a plan to remove that elephant by insisting on a strong wireless communication ordinance. Thank you.
Thank you. Anyone else from the council chambers? Jennifer, anyone online?
I see no more hands on raised online, but just one more time, if you are already joined via Zoom, please raise your hand by using the raise your hand function at the bottom of your screen, or to raise your hand by phone, dial *9. No hands are raised, so I think that was the last one.
Okay, we're going to close public testimony and bring it back to commissioners for deliberation. Mike, are you raising your hand or? Is he muted?
Commissioner Brassfield, I just unmuted you.
I'm not raising my hand, I'm raising my volume.
Okay, who would like to take a stab at this?
I'll go ahead and take a stab. I thought in the last meeting that Kim had brought a draft ordinance that did not entirely reflect the concerns of the subcommittee and specific things that have been brought up by the community. Today, on the other hand, she's presented an answer to just about every one of the concerns that were addressed in the letters that were sent to the planning commissioners ahead of the meeting. Yes, some additional concerns have come up in this meeting, but on the whole, this ordinance would get my support because of the specific attention paid to each one of the issues brought up by the public. So I would support the ordinance.
Okay, thank you. Mike?
Later.
Later. Okay, Mike's saving himself. Terry?
I'm in basic agreement with Sandy. At the last meeting, the homeowners and the people active in the community on this issue were really frustrated that the all of this hundreds of hours of subcommittee hearings that had not been really paid attention to. But actually, a lot of these ideas have filtered their way into the ordinance, and I think it's pretty good. I have a couple of things. I'm not going to certainly fight against anybody in the committee on these issues, but I don't see why. Maybe I might ask staff at some point. Maybe not. Couldn't we have a setback to school property lines? I don't see why we couldn't have 100-foot. I don't know why we need 1,000 feet or whatever, but to have some kind of setback to school properties seems reasonable to me. I think as far as residential properties in the cities, the way the ordinance is constructed, we basically made it clear that we don't want wireless facilities in the residential neighborhoods. And then finally, the Mike Grassfield's idea of having a sort of an apology as part of the ordinance. Staff does not like that idea, and I understand why. I guess it depends on how the planning commission feels about this issue. It does seem strange to have an ordinance with an apology at the beginning. Although it's, I feel frustrated that we are putting together an ordinance with the elephant in the room. We're not allowed to talk about it. Basically the health effects of RF. So there we go. So I think it's a good ordinance, and it's pretty close.
Thank you. Stephen, there you go. Raise your hand. Yes.
Is that me?
Yes, it is.
Okay. I share Commissioner Grassfield's concerns with feds telling us what to do, not having any idea what we need. The same thing happens with the state telling us we're going to have housing without water. It's a very frustrating thing to sit up here and to realize that we're constrained by what we can do. There are those who tell us what we want to hear and those who tell us what we need to hear. I think that staff and our attorneys have told us what we need to hear, not necessarily what we want to hear. And I will support the ordinance with the addition of a 250-foot setback for schools in R1 or residential. Without that, no. Reluctantly, I will support it with that in there.
Steve, can I ask you to clear? I didn't quite understand. You said 150?
250.
200 foot. Okay.
For schools and residences?
Yes.
Okay.
Is that residential property lines or residential's buildings?
Residentially zoned properties.
Steve, I'd ask, what neighborhood could that work in?
Really,
You have, if you put it on, if it's a neighborhood on people on both sides, if you put it on one side of the street or the other, you're gonna be less than 150 feet from most houses.
I think that area was set forth in Kim's response to your questions on the setbacks. There was 250, 500, and 1,000.
And that was the question of the public. I was trying to respond to it in the format of writing it up.
I think we should have a setback on houses and schools. And without that, I would vote no.
Kim, how would that work?
That's another reason why I wanted to have a severability clause in there. So maybe we could go a little bit wilder.
Yeah. Is
Still
it
valid.
okay, through the chair, is it okay if I
Yeah,
comment for just a
absolutely.
second? Okay, thank you. And maybe Gail will want to opine as well. A couple of different things as Kim described during her presentation. We can regulate based on aesthetics, and it would be preferable to regulate to minimize cluttering between poles, which is hard to visualize. So maybe 250 feet between poles, as opposed to a setback from residences of 250 feet or a setback from schools, which needs to be tied to aesthetics. I might also add that there are some schools as property owners that are installing or would like to install wireless on their own property. And so just that's maybe something to keep in mind. There are some schools with kids that don't have capabilities at home. I'm not rendering an opinion on the policy of any of that. I'm just bringing that to your attention. So if Gail would like to give further advice or input on the setback component, that would probably be useful, Gail.
Certainly, thank you. I think that what and maybe Kim wants to comment on this, but I think that the purpose of the map that she included with the analysis was to show that it would, that having that sort of level of setback would actually eliminate the ability to put facilities in areas that you otherwise in your ordinance would support. So it may have the effect of like knocking out some public rights of way and even in commercial areas that you might support. So it has that. I think the purpose of the map was to show that it would have an inordinate impact on limiting where the facilities could be placed. Now, having said that, certainly, there is a balancing act always in these ordinances. And I have seen cities take that chance of adopting an ordinance that has a setback requirement that may or may not withstand a legal test.
Another reason for the severability clause. And that we can do that, the staff do the study for 100 feet, 150 feet, and 200 feet. I'm not set for 250. That's just the smallest one that we have of the three that were given to us. So, you want to continue and take a look at it, fine. You want to vote on it without it, I vote no. I've been pushed as far as I'm going to let them push us. I think the people that deserve something, and I'm going to give it what I think I should do. End of speech.
Yeah, thank you, Stephen. Ray, I had a question for you. Your comment on mock-ups.
Yeah.
You felt that there were other methods of mock-up that would probably apply 99% of the time. Is that
Yeah.
correct? And that the other 1%, was it your feeling that it would be at the discretion of the planning commission to require the mock-up, or was it because it would be a part of the application.
Yeah, that was exactly my thought. Yeah, but it's and maybe she can opine on this. Felt like it should either be in the ordinance or not requiring mock-ups. And I was thinking, well, I don't know. I mean, the planning commission often seems to have the power to require applicants to provide more information. And I don't know why, given a particular application with something in the photo mock-up that looks really ugly, we couldn't say, I don't know about that. Maybe we do need a mock-up in this case. Anyways, does that clarify?
Yes. Yes.
I think that if we were required to go down and look at that relation on phone
That's my
before
point.
anything else got done, you'd take a look at that and they say denied. Because it's that ugly.
No, I was on planning commission when that came through.
Yeah.
That was probably the biggest mistake I've made as a planning commission.
Yes, sir.
Was approving that. And I just, looking back on that, I'm an architect. I can visualize and I read on that one. So
Is everyone's mic on?
yes.
I think that the audience is having a hard time hearing me.
Okay.
Okay, thanks.
Sorry. This is my space. At any rate, I just want to ensure that there's an ability to have a complete understanding of what this facility would be, so that we could all properly analyze it. And I'm not sure if I found a way for that to happen in what we've discussed this evening.
Can I just offer one? And I do think the planning commission has potentially a lot of discretion in this area. The subcommittee debated whether or not wireless facilities should be allowed on existing telephone poles, or whether do you want a separate stealth facility, or some communities have picked a design. And so if you think typically the electrical lines run along one side of a street, the idea that was debated at the subcommittee and was, well, maybe on the opposite side of the street, you put up a new pole. It looks like there are options out there that what it could look like.
I lost on that 61.
And so the discussion that happened at the subcommittee was, it was better to have it on an existing pole because it wouldn't result in a new pole in front of somebody's property most oftentimes, that it would go on an existing pole. And the reality is, I think we all know what they look like. On the shorter poles and the taller poles, there's a radome or antenna on top. There's a piece of equipment. We're trying to get it as close to the pole as possible. The reason why the change in dimension was, I think one company said it no longer met there's the specifications of their equipment. So we tried to get it as small as possible. There is a design choice. Some communities by district say, we want it. I think there was one in Baltimore or something where they look like a historic lamp or something, and they were all designed to look like that. So there is, some communities adopt design guidelines that by neighborhood or by city, we want them to look like this. And as I've thought about our city, I've struggled with this. I get it in the forested areas. You're probably not going to see the facility as much on the really tall poles because there's a lot, there's already the pole there. There's a lot of trees. You're probably not going to see it as much. Del Monte Beach, there's not that many.
Gotta see it.
You're going to see it. And would it be better to have a separate pole with a more, a specific design? The city says we want them to look like this. That is a design choice this ordinance makes. I could see different answers. The subcommittee debated that. They came back with recommendation that's in the ordinance. But the planning commission could say to us, that's not the design we want to see. Staff, could you go and research designs and bring us 10 options? And we could create a specification that designs in Monterey should look like this. May result in a new pole. may result, I don't know what the design, I mean, but there are options out.
Refresh my. For 13 small. Couple of them actually we voted on, is that correct?
Just one.
Did not have a discussion about moving that equipment into a vault in the ground.
So I don't remember the specifics of that application. I could unearth that. Some of the poles that were, or some of the facilities that were proposed at the time had ground mounted equipment and others didn't. I don't remember on the specific one you voted on.
Okay. I just think of that one down. Equipment box mounted on the pole, it's obnoxious. If that wasn't there, you might not notice the rest of it as much. Is what I look at.
And so those might be design choices we could bring back to you.
And totally aesthetic.
They're totally aesthetics. You have the ability to regulate aesthetics in the city of Monterey. This ordinance has an approach. I don't know if it's the right approach for the city.
I would suggest that the amount of work that Kim alluded to on maintaining these poles for an inspection site, and then the amount of labor of also tearing them down. I personally, I can understand plans. And we've been looking at plans tonight, and we've managed to find some reasons why, looking at the plans, we weren't ready to make a decision on it. I think that we could do the same thing. So maybe if Kim could come back with these alternatives, if we didn't like the original design, I think that's viable.
Okay. Further discussion?
Okay, I will. Want to get everybody else to get their 2 cents in. One of the things I've noticed in this process, first of all, we've given a whole lot of work to staff and Kim, and they've managed to muddle through it these past couple of years. And I applaud you for that. We've heard from the public, tried to respond to all their concerns. Personally, I've read the original act, I think it was 94 that started this. And in 2000, they had another one, no, 2020. And then we've had court decisions, and I've talked to people in other cities that have similar ordinances, and they're basically pulling their hair out doing the same thing we're doing. So I can say that I think that we've taken a good look at this issue, and I like what Steve is suggesting, some kind of a setback. I'm trying to picture that, particularly in my neighborhood. And I don't know how it would work, but it's something I think that we need to consider. And I'll just leave that as my position. I do support the rest of it, though. Thank you.
Thank you. Would someone like to take a stab at a motion?
Aren't the opine? Oh, yes, I did.
You did. Do you want to know any more? More? Steven, you want to take a stab at a motion?
Guess not.
I move to continue it until we can get feedback on 100, 150, and 200-foot setback from residences and schools. If we can't affect the schools, they can do what they want on their own.
Yeah, that's true.
You making that a motion, Stephen?
Yes. Continue it to the next next feasible date, whatever staff tells us is.
So I think that's fairly straightforward to do. And I think we could, I think we can make the 27th of September, if we can continue it to that date. Although, Gail and Chrissy, are you guys both available on that date or no? Should we push it one more meeting? You want to put?
I'm available.
Okay.
Steve, in your view, are the three outstanding issues, the mock-ups or no, the setbacks, and the specific design for Monterey?
My only concern at this point in time was the setbacks, but if you,
Well, I'd like to see those other items added on there.
Yeah.
Yeah.
Those seem to be the three outstanding ones.
Steve, would you be willing to roll those other items into your motion?
absolutely.
Thank you.
Steve, what about your comment about bonding? That's a new, that's a entirely new issue. Would that bear some discussion?
I had mentioned that before and
Yeah. we've
nobody
discussed
ever
it.
got back to me on it.
I can answer that question.
Good.
There is if I may, there is a government code provision in California that allows you to, as a condition of approval, require a removal bond.
That's what I'm speaking of.
Okay.
I don't think it's a bad idea. I mean,
I think it's a great idea.
considering, the satellites, Mr. Musk is going to have a satellite every 200 feet up in the sky. So there we go.
I want to thank Gail. I finally got something right.
Okay, we have a motion. Can we have a second?
I second. Well, that's my motion.
And it's 4 items right now.
Yeah.
And Sandra was the second?
Yeah.
Okay, further discussion
Specific
before we
Monterey.
take a roll call vote?
Can never require them.
Before you close it, I would like to get another comment from Gail when we're after the vote.
Prior to the vote, you're saying?
Mhm.
Correct.
Okay, what is the comment, Mike, that you wanted to?
Well, I was going to ask her what's the latest that she's heard regarding Carmel, because it's been tossed to us a couple of times in the last couple of meetings.
Can we do that after the motion, please?
That's what I asked. I said we can do it after the vote.
Okay, I'm not sure if what you wanted to ask was pertinent to our vote.
No, not pertinent to the vote.
Okay, and I do want to clarify the continuances to September 27th will be our goal.
Yes.
If not, we will continue that from that date, but
Okay.
our goal will be to make it on September 27th.
Thank you. Jennifer, roll call vote?
Chair Fletcher,
Yes.
Vice Chair Milich,
Yes.
Commissioner Brassfield,
Yes.
Commissioner Dawson,
Yes.
Commissioner Freeman,
Yes.
Commissioner Latassa.
Yes.
Okay, this item is continued to September 27th of this year.
Okay, thank you. Back to Mike's question for Gail.
So I can tell you probably only the same thing that you may know from seeing any public noticing or anything like that. The city of Carmel is looking at updating their wireless regulations. They put out a draft set of regulations and for public comment, and have not set a date yet for the public hearing on those drafts.
But has there been a case decision on the lawsuit?
The lawsuit that if you're referring to the one Verizon sued the city over a denial, that I represent them on that case. We were successful in a motion for summary judgment, and Verizon has appealed that to the Ninth Circuit.
How does that apply to our ordinance?
That's dealing with a specific application and the requirements for Verizon was contesting whether the city had acted based on their interpretation of federal law. They believed that a notice would have to be delivered to the applicant to qualify as a denial in writing. We prevailed on that issue. I believe your ordinance does require the decision to be provided to the applicant, so it wouldn't come up in your situation.
Thank you.
It was a very narrow issue.
And that was a magistrate's opinion, right?
Yes.
Okay. Thank you.
Okay, that was helpful. Thank you. Yep. Yes, because we are under commissioner comments right now. So yes.
The question of staff, has someone talked to PG&E about the design of what these poles are going to look like? Because somebody's going to have to climb through the voltage to get to the radome. And I don't think they're going to like that. So I think someone needs to talk to PG&E and get a go ahead.
So I'll be happy to reach out to our local PG&E office, but this is being done throughout the state of California right now. And so there are minimum distances between
6 feet,
the actual wires and where the facility can be on that pole.
Yeah.
And so
I used to climb those poles.
oh, there you go.
Yeah, I tell you, you get close to the high voltage and the hair stands up on your arms.
Yeah.
So
I have a question.
very dangerous to climb through the voltage.
Well, they're going to have to shut off the voltage to climb.
I don't think so.
You know, we have what, 4 major cell phone providers in the area. Was the T-Mobile and AT&T, Sprint, and another.
We have Dish as well. I think Dish is taking over.
Okay, and I'm wondering, I'm wondering with co-location, do we have any pictures of a co-location, a pole with all 4 of them on it, or how does that work aesthetically? I'm having trouble trying to visualize all the equipment that is there in support of it and how it fits in and what it looks like. Does staff have any or access to any photographs to maybe show us what it would look like?
You know, I'm going to reach out to the carriers and get examples. And then I'm also, I remember, I think, well, BBK in the past, I know Joe Van Eaton had a lot of visual examples. He showed us some great ones. I think it was in Baltimore or something. They made them all look a certain way and they weren't that ugly. It granted was a brand new design feature in your public right of way. So I think I appreciate we're going to have the design discussion. And if the community ends up that it's on the existing poles, that's fine. But just understand what that's going to look like.
I've said several times that if this thing was as big as a deck of cards, no one would care. But it ain't.
It's not. Yeah.
It's not.
True. Also, I think that as sharp as some of the public comments were tonight, they had those comments prepared before they came in. They had them prepared before you made your presentation. And the fact was, I don't think they really listened to what you had to say in response to the request for information. These were just the same comments they were going to make anyway.
Okay. We'll move on to informational reports and staff comments.
I'd like to bring up another topic. From the very first hearings we had on cell towers until tonight, we heard one of the same issues. An issue came up and questions were asked regarding RF, and there was the answer from the people with the project that always, I'm sorry, we don't have one of those here tonight. That really makes it difficult to sort through these things if you can't get the expert that these companies are supposedly relying on to answer the question. I don't know how to, if we can address it in an ordinance section by putting in there, you shall have an RF engineer available for questions in hearing. I don't know. maybe in the application that the questions will be asked and it's expected. I don't know. I don't know if you run into, I can't think of another issue where this comes up, Kim. Can you?
Well, I agree with you. I think the project we looked at earlier this afternoon, that was just really bad exhibits. I was shocked actually, once we took a
Did you
closer.
notice all the little dots of all the different
Yes,
antennas? There's had to be 24 of them.
I just feel that asking for certain information in order to make a decision about something, we should be getting accurate and reliable information from the applicants, and we're not getting that, and that
Okay.
concerns me.
Yeah, I'm sorry, pardon my interruption, but this was a earlier item on the agenda, I believe.
So we have to,
We should,
We're talking about the problem, not the issue.
okay.
in specific reference to that application, I'd suggest there not be a discussion on that.
That's fine.
Okay, we won't talk about that one. We'll talk about the first one.
Well, there
We
shouldn't,
didn't have an interest.
at this point, this is
Yeah,
commissioner
'cause we-
comments. It would be problematic under the Brown Act, so I'm advising that that not occur.
Okay,
Okay,
I have a commissioner comment.
okay.
Well, I would hope that any photo montage that's ever presented is closer than 3 blocks away.
Okay,
And
thank
if
you.
they do a 3 block away photo montage, they should have next to it a blow up of the part of the thing that you really want to see, and not just, that's general comment, not the world, the universe.
That's what happened in the 13. Little men were just, what?
You can see, I mean, they're probably, if you do
It
a.
seems like we're walking a tightrope here.
Okay, good
Yeah.
enough.
Kim, could we schedule that for the 27th?
Wait,
We
we're,
can discuss it?
let's just hold off on these comments that have anything to do with communications, wireless, anything. Those, our hearings are closed on that. And I think we just need to move on to staff comments.
So just, our priority is to continue to resolve the wireless ordinance. So you'll see us continue to push the ordinance through the various hearings. Another priority for us is we're wrapping up SB 35, which is compliance, which will require amendments to our specific plans in light of new housing laws. So we're getting very close to presenting amendments to the specific plan with a checklist for affordable housing projects that meet certain criteria. So that's almost completed as well. After that, we're going to be working on our Sb9 checklist, which is where the new state law where you can subdivide a property into 2 and build these 3 additional units, total of 4 on the property. So I just wanted to give you an idea that those are the advanced planning items that we're working on to comply with law. So I hope by the end of the year, all 3 of these will, in some form, be pushed forward to the city council.
Great.
Okay.
Anything else? Okay,
I have one thing I'd like to add. This Saturday at noontime at Via Paraíso Park, Monte Vista Neighborhood Association is having its annual barbecue. It's $10 a person, kids are less, and of course, you're all invited.
okay, thank you, Stephen.
Thank you.
Okay, with that, I'll adjourn the meeting.